Hello, very good morning, very good evening to you. Welcome to The Point of View. The Point of View is live on Channel 1 television. We are live also on our socials. The Point of View is your most watched evening current affairs program, and on The Point of View, we select the right topic, we ask relevant questions, and bring you relevant guests and ensure that you have some insights at the end of the day. Tonight, we have a very relevant topic for indeed the biggest topic in Ghana today. The Chief Justice, Gertrude Torkonoo, has been removed from office pursuant to Article 146 of the 1992 Constitution. We'll bring on analysis and reactions of her removal from office. Others say that it is in adherence to the rule of law. Others also say that it is a bad precedent that will come back to hurt the country in many ways. What do you think? We'll be happy to hear what you think on 020-444-7033. We'll be happy to read your comments to the rest of the world. My name is Selom. I'm sitting in for your regular host, Bernard Koku Able. I'll take a short break, I'll return, and then introduce my guest to you, provide some updates indeed, and then we will hit the ground running. Don't go away.
Announcing Ghana's first unlimited photocopier leasing. Yes, from just 983 Ghana cedis, you can lease a multifunctional photocopier and print unlimited. Yes, unlimited and free paper every month. Guess what? That's not all. Toners, repairs, and maintenance all are free. And oh, I'm not kidding at all. And we cover the whole country. Yes, the whole country. What are you waiting for? Just visit us at www.valexlease.com or call 0244 644048. Remember, terms and conditions apply. Valex Lease, affordable document management solutions.
Remember who we are seeing now. At risk of prostate enlargement. We a member or her 20 ebitiminya prostate cancer. 5 bitimi afamu. Nadia ubefamu.
Actually, this is not my fault.
And to wada, entina midi maniche Executive Prostate Center.
Executive Prostate Center is a unique medical center where we harmonize in-depth traditional medicine with cutting-edge science and technology to cure, to treat, and to prevent diseases like prostate enlargement, prostate cancer.
Executive Prostate Center. Madame home facilities no any professional medical care.
Sisi a bibia clear system no. Ye nro ne so de natural. Into we koso afama ye.
Executive Prostate Center. My cured.
Kwame and his uncle are almost here.
Wait a minute. This one too, your friend Kwame.
Wait, Kwame. As in the same Kwame again?
Yes, Mommy.
The second coming. Into all this tension just to reintroduce that broke boy from Kaswa.
Why would you deceive the family like this again?
Now I understand the whole delay. Troll from Kaswa. Why wouldn't he be late? Or being late?
Of course.
Star 712 hash, star 712 hash. Yeah, you go be the luckiest. Coffee from Georgia be luckiest. From not the Pia she be luckiest. Me and you go be luckiest. Nobody know why that luckiest. Everybody go be that luckiest.
That's Kwame!
Senya God the apple boom. If you put it toye, so would the coming of the son of man be. Is that his car?
Dial star 712 hash. Choose your ticket. Enter your lucky number. Follow the prompts and let destiny handle the rest.
This promotion is regulated by the NLA on the Caritas platform.
You're welcome back. This is the Point of View on Channel 1 Television. I am Selo Madunu, sitting in for your regular host, Bernard Avlet. Tonight, we are looking at the removal of the CJ, the Chief Justice of the Republic of Ghana. Until now, Justice Gertrude Torkonoo is being removed from office by the President this afternoon, pursuant to Article 146 of the Constitution. The process began sometime beginning of the year, soon after the President took the reins of government. 3 persons petitioned for the removal of the Chief Justice. A process was initiated, and that process essentially concludes today. Just to provide you some context, the Chief Justice, Gertrude Torkonoo, she was sworn into office as Chief Justice on June 12, 2023. And then today, 2025, September 1, that process comes to an end. She began her judicial career as a High Court judge from the 14th of May 2004 to October 2012, when she was appointed to the Court of Appeal. She did that till December 2019, when she was nominated for the Supreme Court and sworn into that office on December 17, 2019. She did that till today because even though she was Chief Justice, she was still Supreme Court Justice. You have to, that's how it works. So she was Chief Justice from 12 June 2023 to today, 1st September 2025. Indeed, she became the 15th Chief Justice of the Republic of Ghana, and indeed the 3rd female to have occupied that position, coming after Justice Georgina Wood and then Justice Sophia Kufu. So 3 petitioners, Daniel Ofori, Ayamga Akogo, and then Shining Stars, petitioned the President for her removal. They stated a number of allegations, and then eventually the process is concluded. The basis for removal of a Superior Court judge under our Constitution are 3. 1, stated misbehavior. 2, incompetence. And then inability to perform functions arising from infirmity of body or mind. In accord with the constitutional provision 1466, the President, upon receiving the petition, forwarded it to the Council of State, after which the Council of State looked at it and a determination was made of prima facie against the Chief Justice. The President eventually suspended the Chief Justice in accord with law and constituted a committee, a 5-member committee made up of 2 Supreme Court justices and 3 other persons to look into the matter. So it is this committee that concluded its work today. Members of the committee include Justice Gabriel Poaman, who is a Justice of the Supreme Court, Justice Samuel Kwame Adibu-Asiri, also a Justice of the Supreme Court, Daniel Yao Domelewe, former Auditor General, Major Flora Bazanura Dalugo of the Ghana Armed Forces, Professor James Sefa Jisa, an Associate Professor at the University of Ghana. So we heard today from the committee chair, Justice Poama, that the Chief Justice called 12 witnesses, including experts. Daniel Ofori, the petitioner, called 13 witnesses. They reviewed some 10,000 pages of documentary evidence. The petitioner was represented by 4 lawyers, and then the Chief Justice also came in with 4 lawyers. So this is Gabriel Poaman presenting the report of his committee's work to the President. Indeed, he made a few remarks before eventually presenting that report. Let's hear him.
Mr. President, in March this year, you received 3 petitions pursuant to Article 146 of the Constitution 1992 for the removal of Chief Justice Gertrude Asaba Araba Sakitokon, and the public was made aware of this fact. Subsequent processes dictated by the Constitution and the decisions of our Supreme Court were gone through, culminating in the establishment of our committee under Article 146, Clause 6 of the Constitution. The nation was further duly informed. And when we commenced our work on the 15th of May 2025, the Minister of State for Government Communications was briefed and notified the public about it. There has been considerable interest in our work, shown through comments and opinions by Ghanaians and international observers as well. However, the committee restrained itself all along from reacting, even when blatant false statements were made about members of the committee and our work. To the committee, our mandate and remit is set out under Article 146, Clauses 7 and 8 of the Constitution. It's clear, and it is to inquire into the petitions in camera, hear the person against whom the petitions have been brought in her defense, by herself or by her lawyer or other aspect of her case, and then make a recommendation to you, Mr. President. As I have said above, 3 petitions were referred to us. And though all 3 petitions seek the same relief, each petition is distinct and would succeed or fail on its individual strengths or weaknesses. Mr. President, without disclosing the substance of the proceedings, and since in-camera proceedings is not the same as in secret, we can state that in respect of the first petition, we received evidence by Mr. Daniel Ofori, the first petitioner, through 13 witnesses. Similarly, the Chief Justice in her defense called 12 witnesses, including expert witnesses, as she is entitled to do under the Constitution. The Chief Justice testified personally and was cross-examined. The committee received about 10,000 pages of documentary evidence from both sides. There were 4 lawyers that represented the first petitioner, Daniel Ofori, and 4 lawyers represented the Chief Justice. Mr. President, after critical and dispassionate examination and assessment of all the evidence, including the expert evidence, against the provisions of the Constitution and the relevant laws, we have, without fear or favor, arrived at a recommendation on the first petition. The recommendation is contained in the envelope which I now give to you.
All right, so that's Justice Gabriel Poaman, who chaired that 5-member committee, made those remarks when he presented the report of the committee to the president. So soon after that, a statement was issued that essentially told the Ghanaian public that CJ Torkonoo had been removed from office. Also, a warrant was signed for her, and then she was written to officially all today. And so as we speak, by virtue of the processes that have been activated and the processes that have been gone through, CJ Torkonoo is no more the Chief Justice of Ghana. My guests this evening are the Honorable Hassan Tampuli, who is the Member of Parliament for the Gushewu constituency and ranking member on the Deputy Ranking Member on the Constitutional, Legal and Parliamentary Affairs Committee of Parliament. I have Martin Kwebu, who is a private legal practitioner, and of course, the Honorable Roxy Nelson Dapiamapo, who is Member of Parliament for South Dai, and also the Majority Chief Whip. Gentlemen, you're welcome to the program.
Thank you very much.
Yes, let me start off with you, Hassan. I mean, did this decision come to you as a surprise? I mean, the event started early in the early in the term of John Mahama. We saw the petitions, or we heard that 3 petitions were submitted to him. He forwarded it to the appropriate courts. The processes kicked in, and I conclude today. Are you surprised at the outcome?
Thank you very much. Good evening, and good evening to your esteemed listeners and viewers. So, I think there's no Ghanaian who will be surprised about the outcome of the committee's hearings today. The way it started in the run-up to the elections, about reset, and then the attempts probably to find a way to restructure the judiciary and so on and so forth. Threats have been made, and if you recall, during the transition period, the Honorable Minister for Communications, had said that the president has to purge the judiciary. Honorable Sam George, he says some things to that effect. So it wasn't really a surprise when we heard that there were petitions, for the removal of Chief Justice.
But it wouldn't be the first time a petition was filed. Professor Azar filed a petition
against her.
The petition was dismissed a day before President Akufo-Addo left office. So it's not entirely strange that there'll be petitions against this particular.
No. As a matter of fact, this is not the first time a Chief Justice has been, threatened with the removal by way of some of these petitions. Just Lee Kingsley Akwa was also challenged in that regard, and that's where we have the case of Asari versus Attorney General and so on and so forth. Aban's, appointment, there was an attempt to remove him. There was an attempt to remove almost, a lot of judges. But the history is that the first time we ever had this situation was, I think, somewhere in 1963, when Osajefo, Dr. Kwame Nkrumah removed Seyaku Kosa as Chief Justice, and I think almost immediately he was detained for some hours before he was released as Chief Justice. The next time we had some of this experience was sometime, I believe, in 1976, when Kutua Champon was the head of state, SMC, and Azu Krab was the Chief Justice. I think there was some student protest, and the student made some demands to the effect that Achampon should quit office and hand over to the Chief Justice. And Achampon got infuriated. The next day, he removed Azu Krab as the Chief Justice, and then in his place was appointed Apalu, who stayed in office up until somewhere 1985. But Ghana has joined the ranks of Pakistan, Sri Lanka, Bangladesh, and Maldives as one of the countries that has removed their Chief Justice. Now, it puts it in very bad company.
But given the history you provided,
it puts us in very bad company.
This is not the first time. So Ghana has always been in the league of countries that have
Ghana hasn't been in the league. If you look at what happened in 1976, the removal of Azu Krab, it was under the military regime.
Aku Kosa was
all right. Aku Kosa was removed. Of course, we know what happened, during the First Republic.
But it wasn't a military
they could remove almost everybody, all right? And now, this constitution provides mechanism for the removal of Chief Justice. And it provides that Chief Justice may be removed on grounds of stated misbehavior, incompetence, or inability to perform the functions of the office of Chief Justice by reason of infirmity of body or mind. Now, what is misbehavior? What is stated misbehavior? Now, obviously, from what we have seen, the fact that a Chief Justice's spouse traveled with her, all right, and earned per diem has now been added to what constitutes stated misbehavior. Seriously, this is ludicrous, highly, highly ludicrous. It appears that sometimes when we were in law school, they will tell you that in some instances, some judges will determine cases before they hear. This appears to be one of those things. The sin has been set for her removal. We now have to look for basis to remove her. That is what all these things are all about. Look, if a justice of the Supreme Court has misconducted him or herself, or a Chief Justice, or has engaged in a conduct which falls under the stated misbehavior, it is so palpable that you don't even need, to go into the nitty-gritties to know. A judge has gone to take bribe. A judge is drunk, all right, intoxicated, and sitting on cases. A judge is having some amorous relationship with litigants and staff, and so on and so forth. A judge is involved in perjury, corruption, morally reprehensible conducts, tax evasion, and so on and so forth. When you talk about this thing, it's so easy for people to connect. But to say that a Chief Justice has traveled with the spouse. Now, mind you, what the allegation is about is that the Chief Justice ought not to have traveled with the spouse because it has not been provided for under the condition of service.
So the letter to her,
yes,
given the grounds you are stating,
exactly,
says that those acts constitute avoidable and reckless dissipation of public funds and in the view of the committee to have been occasioned by the overall head of the judiciary and the judicial service, whose duty it is to guard public resources allocated by the government, is caught within the spectrum of stated misbehavior. So the point is,
let me tell you something.
You don't have to travel with your spouse or your child and make them earn
That's
per
such a
diem
very egregious
on account
conduct
of the state purse.
that the whole head of the judiciary, the third arm of government, should be removed. Let me tell you something. This Chief Justice, even if she had crossed the red lights, traffic offense, she would have been removed from office. Of course, you understand what I'm saying? She's already been penciled to be removed. So whatever it is that would have been used to remove her from office.
So are you saying that the fact that the husband or her spouse and her child benefited from state funds in a manner that the committee felt they shouldn't have benefited is not enough to occasion her removal?
It is de minimis.
So what should have been done? We should have forgiven.
No,
we should have forgiven them.
And something that was not available to her, she could refund. And we have seen people
if that's the case, everybody could go do something wrong and you refund.
Appear before the Public Accounts Committee, public servants in different capacities, and then there is surcharge, and so on and so forth. You'll be asked to refund the money, and so on and so forth. So I'm not too sure the Chief Justice set out to more or less engage in acts of corruption.
But we don't know that, do we?
No, we do. Some people appear before the committee.
And you know what they
give
said?
Testimony on her behalf. Of course, some of these things, like before the release of this statement, somebody like Captain Smart, I chanced upon it on TikTok. Captain Smart was reading copiously from.
I didn't hear him.
I saw it.
I
saw exactly what Captain Smart was reading from, and it is the same portion.
So the point is that
you understand. So these matters were already known that this is what we are going to use to nail her. Whether it makes sense or not, we just have to find a way to nail her. And I think this is a very sad day for our democracy. It's a very sad day for our judiciary. Our judicial independence is gone. Look, if you can delete the Chief Justice the way that she has been deleted. Now, other justices of the Superior Court, High Court judges, Court of Appeal judges, and other Supreme Court judges, and even Circuit Court judges, I mean, they'll be so scared that, look, what would I do and not incur the wrath of the powers that be? If the Chief Justice, when the threat was made to remove Aban, his colleagues stood by him. All right, justices of the Supreme Court, they stood by him when Ghana Bar Association went to court. When there was an attempt to remove Justice Kinsley Akwa, these colleagues, when the matter went before, they stood by him. She didn't get the protection from
but is it not strange that in the instances you have mentioned, their colleagues stood by them, but in this case, it didn't appear so?
That is what I don't understand.
Because their colleagues were on the same bench together, almost appointed by the same person. They were there together, and so perhaps it's an indication of how they saw her or what she did whilst on the bench. Justice Aban's colleagues stood by them.
Yes.
Apalu's colleagues stood by them. And the examples you've mentioned.
Precisely.
So is it not curious that in this particular case, Justice Torkonoo's colleagues on the bench did not turn up for her?
No, so one is not too sure about exactly what is happening. But what is important is that the personality of the person shouldn't be the reason why you should stand by the person, but the principle.
Yeah, but if the personality violates the principle, you don't stand by the person, do you?
See, since it's so easy to remove the CJ, a new CJ will be appointed. Trust me, every president will come with his own CJ.
Very well. Let me speak to Martin.
Every president will come with his own CJ.
Martin, I mean, were you surprised by the decision? I mean, Honorable Tampuli thinks that this certainly is a sad day for Ghana's democracy and the judiciary as well. Judicial independence is gone. He seems to suggest. What do you think? Sad day for Ghana's democracy or good day for rule of law?
Oh, Salam, this is absolutely a good day for the rule of law. Now, Hassan Tampuli is speaking as a politician, not as a lawyer. So, I mean, I can see the difference. Some of the statements he's made, I'm like, is that Hassan Tampuli, the lawyer? And come on, we can't continue like this. because today he's wearing the hat of a politician. He's saying all those things. But let's not forget, Hassan, don't forget, the internet doesn't forget. These things you are saying willy-nilly. After Parliament, I can guarantee you, you can't stay in Parliament forever. Someday you will return to private practice, and then these words will be played back to you. Then you will see that it's not everything you should say as a politician. Look, Salom, the things that were the allegations in the petition are serious matters of governance and rule of law. So I'm surprised that he's playing, politics with this. It's not on. I mean, come on. These are very serious matters. Our only handicap is that we don't know which of the grounds succeeded. So that's how I found it.
The grounds that succeeded are in the letter to her. One is the one which deals with the per diem, the travel with the spouse, vacation with the spouse and the child. And the other one has to do with the fact that she suggested some names for appointment or nomination to the Supreme Court. The committee is of the view that she could not lay claim to ignorance of the nomination process and procedure, notwithstanding the fact that the process and procedure are not spelled out in the Constitution by case law. It goes ahead to say that the appointment of the CJ herself as a justice of the Supreme Court went through the very process and procedure set out in the Ghana Bar Association case. Therefore, to seek wittingly to outwit this known process and procedure for appointing Supreme Court justices amounts to misbehavior in the eyes of the committee, and the committee finds it as such. Martin, if I recall, you were one of those voices that spoke against the CJ when she attempted to suggest the names to the president for nomination to the Supreme Court. So the committee appears to be agreeing with you in that respect. But many people have thought that names surely must come from some quarters. It could be from chiefs who will make suggestions to the president who nominates. It could be anybody. But in the end, it's the president that takes the final decision. So the CJ, being the occupier of that position that sits with other Supreme Court judges, obviously will not be very wrong in suggesting to the president that these 5 colleagues of mine or these 5 persons I think are worthy of the Supreme Court, so kindly consider it. So should that be a ground for her removal?
Oh, Salon, I agree that it should be a ground because you see, there is a Supreme Court decision, Ghana Bar Association versus Attorney General, etc. That's the case that involved the very Justice Puama, who is chairman of this committee. The context is that the Judicial Council sent a list of recommended judges to President Mahama for appointment. And they thought that Mensah Bonsu should have been appointed because she was higher up the list. So Mensah Bonsu was definitely ahead of Justice Puama. And then, and then also Mafu Sound appears. But at least very clear in the judgment, it was clear that Mensah Bonsu was ahead of Justice Puama. And President Mahama didn't appoint Mensah Bonsu, who was subsequently appointed by Akufo-Addo. So when JM didn't appoint Mensah Bonsu, but rather appointed Puama, the Ghana Bar Association went to court. And as part of...
No, Hassan, let him finish.
Well, Hassan, that's how the law works. Yes, so you have a point that is not exhaustive, but the committee seems to agree with the Ghana Bar Association versus Attorney General decision. So who knows? Hassan, the point you are making, maybe tomorrow we will expand it, so I cannot take that away from you. But currently, at least, the Supreme Court decision is more binding on the committee than your opinion now. So for now, it's the Supreme Court decision we'll go with. So you see that with that thing, we just felt like, you see, the way it was done, that list going straight to Akufo-Addo. And let's not forget, the context was that at that time, Akufo-Addo had been misgoverning badly. Led us to the IMF, cost of living was high. And you know, a hungry man is an angry man.
But Martin, the suggestion by the Chief Justice, Hassan, the suggestion by the Chief Justice for a certain number of justices to be nominated has nothing to do with the so-called misgovernance of Akufo-Addo. You don't agree?
Oh, But no, I disagree. So it fed into the context of misgovernance that, oh, these are the things you guys do behind our back. So it fed into the narrative that here again is Akufo-Addo on a frolic. Akufo-Addo, misgoverning. So here again, he's about to engage in another bout of serious misgovernance. So look, and that's why Hassan.
Akufo-Addo has retired.
No, Hassan, let him conclude.
Now, the election results speak for themselves. You can say whatever you want. I'll just show you the election results.
So Martin, just stay on topic, yes.
Yes, so that's it. So the point is that these are serious matters of governance, right? So I'll remind you again, because I'm handicapped, the grounds that maybe we should have seen the letter. I think that it was leaked to you alone. Maybe I should have seen it.
Is all over the place. Martin.
So yes, the one ground is the per diem that the spouse and the child benefited from when they went on that vacation. So the committees of the view that it constitutes an assault or dissipation on the public purse, and the CJ ought to have known better. So that was what they described as a stated misbehavior.
Excellent, Salom. That one was.
How can this one be excellent?
Let Martin make his. No, he was quiet when you were making your point.
Of per diem be
I'm not sure
excellent point for removal of Chief Justice.
I'm not sure he agreed with you, but he made you make your point. So Martin, go ahead and make your point.
Salom.
Yes.
The problem what Salom is, what Hassan is faced with, and the truth of the matter is that, you see, what Hassan is trying to say, and which is plain truth, is that our politicians, right, those in the executive, ministers, deputies, often abuse the public purse way beyond what the Chief Justice was involved in. That's the truth. So often, when you see what the Chief Justice is being punished for, it is chicken change compared to the way, Hassan was a deputy minister, etc. So I can understand where Hassan is coming
don't bring me into this discussion.
So, Hassan, it's true that in the ministry,
you guys are doing a every now and again, you bring Akufo-Addo, now it is Hassan. Please, let's stay on the subject.
Hassan, let him conclude.
Let's deal with the matter.
He's trying to explain.
Martin has not seen the letter.
No, yes, but
that is why he's doing agamalism.
But he knows that.
Maybe you should share the letter with him.
He knows the
because he thinks that there's whole issues that the Chief Justice should respond to. But there were 3.
Wait, he knows.
In fact, even violation of Article 296 has been used against the Chief Justice.
We are just
is this committee the Supreme Court?
He knows the grounds because he's seen those letters that came long ago. So we are just pointing to him
that 21 grounds. So he thinks that the 21 grounds.
Yes, so we are pointing to him that these are the specific
grounds.
So
3 issues.
The grounds are not new to him.
Exactly.
All right, Martin. So conclude. Let me take a break.
Yes. So Salom, let's feed in this. I'm telling you that. Let's make this point for the executive. At a certain point, I don't know if they changed it, but you can ask Hassan. When a minister travels, there's what they call unaccountable impress. There is the one that you just chop free. It doesn't come back. I think the last time we were talking about $10,000 at some point, right? $10,000. It just goes into your pocket.
When you travel for days. And so your per diem is calculated according to the number of days. Travel days, stay days, and so on and so forth. So how can you just say $10,000 just like that? Martin, please.
Hassan, is that something?
Is it a fact that you have unaccountable impress?
Is that unaccountable impress?
Every agency has their own policy.
Exactly. So that's what he's saying.
Every agency has their own.
So how because it works for you, the executive, you assume that is how it works. And so, given that she's being removed on this, which he says appears like chicken change to you,
that is it's
outrageous.
I am saying that we have watched time and again that people have appeared before the Public Accounts Committee for funds that have been misapplied or misused and so on and so forth. And they have been asked by virtue of, what's the name of the terminology? To refund the money. I'm saying that why wouldn't the Chief Justice be given the opportunity to also, if they think, if the view is that she had taken some amount of money to be passed to her spouse and her child, then she should be made to refund the money. I mean, what's the big deal?
I see. Let me take a break. We'll take a short break. We'll come back and we'll hear from Nelson Roxin Dapiameko, who is a majority chief whip. He has some views on the matter. We'll speak to him. And of course, my 2 other guests, Hassan Tampuli, MP for Goshewu, and Deputy Ranking for the Legal and Constitutional Affairs Committee of Parliament, and of course, Martin Pebu, private legal practitioner. This is The Point of View. Don't go away.
uncle are almost here.
Wait a minute. This one too, your friend Kwame.
Wait, Kwame. As in the same Kwame again?
Yes, mommy.
I'm the second coming. Into all this tension just to reintroduce that broke boy from Kaswa.
Why would you deceive the family like this again?
Now I understand the whole delay. Trotro from Kaswati. Why wouldn't he be late? Obey you later.
Of course.
Star 712 hash, star 712 hash. Yeah, you go be the luckiest. Coffee from Georgia be luckiest. From not the cause she be luckiest. Yeah, you go be luckiest. No matter why you're luckiest. Everybody go be the luckiest.
That's Kwame!
Senya God the apple boom. If you put it toye, so would the coming of the son of man be. Is that his car?
Dial star 712 hash. Choose your ticket. Enter your lucky number. Follow the prompt and let destiny handle the rest.
This promotion is regulated by the NLA on the Caritas platform.
Announcing Ghana's first unlimited photocopier leasing. Yes, from just 983 Ghana cedis, you can lease a multifunctional photocopier and print unlimited. Yes, unlimited and free paper every month. Guess what? That's not all. Toners, repairs, and maintenance all are free. And oh, I'm not kidding at all. And we cover the whole country. Yes, the whole country. What are you waiting for? Just visit us at www.valexlease.com or call 0244 644048. Remember, terms and conditions apply. Valex Lease, affordable document management solutions.
Remember who we are singing now. At risk of prostate enlargement. We remember or her 20 ebitiminya prostate cancer. 5 bitimi afamu nadia ubefamu.
Actually, this is not my fault.
And to wada, entina midi maniche Executive Prostate Center.
Executive Prostate Center is a unique medical center where we harmonize in-depth traditional medicine with cutting-edge science and technology to cure, to treat, and to prevent diseases like prostate enlargement, prostate cancer.
Executive Prostate Center. Madame facilities no any professional medical care.
Sisi a bibia clear system ni. Ye nro ne so de natural. Into we koso afa ma ye.
Executive Prostate Center. My cured.
Welcome back. This is the point of view. We are looking at the matter of the removal of the Chief Justice. The President today, pursuant to Article 146, removed the Chief Justice, Gertrude Torkonoo, from office. We are looking at the matter, the circumstances surrounding her removal, and we'll soon zoom into what consequences or implications her removal will have for herself and for Ghana as a democracy. My guest, Hassan Tampoli, Member of Parliament for Gushewu, Deputy Ranking on the Constitutional, Legal and Parliamentary Affairs Committee of Parliament, Martin Pebu, Private Legal Practitioner, and the Honorable Roxanne Nelson Dapiamapo, who is the MP for South Dai and, of course, the Majority Chief Whip. Roxanne, good to have you. Many people say that this decision did not come to them as a surprise, but what is surprising to persons like Honorable Hassan Tampoli is the frivolity, not in so many words, but the frivolity of the grounds upon which the Chief Justice of the Republic is being removed. What do you say?
First of all, it's absolutely incorrect for Hassan and some others to suggest, however whimsical that is, that the grounds underpinning these petitions that went before this Article 146 committee were whimsical and frivolous. There were no frivolities at all. So let me respond. Let me respond to these matters this way. One, you recall my case against the first ladies? The first lady and the second lady, when the Professor Yaintiamwa committee merely recommended that they were to benefit as Article 71 office holders and earn salaries. You remember?
Yes, I do.
So I waited until that report came to Parliament, and Parliament approved, as it were, of those recommendations. So they became implementable. So after the parliamentary approval of that article, Professor Yaintiamwa report in respect of the Article 71 office holders and its benefactors, I went to court. The Supreme Court determined, and that panel was presided by the CJ herself. The CJ said the wives of the president and the vice president were not entitled to bonuses, allowances, anything that were attachable to the office of the president and the vice president. They cannot benefit. I didn't say it. She presided that panel, and she made that pronouncement. So
by
that
extension,
is the law.
by extension,
Hold
the
on.
spouses or her spouse and her child could not have benefited from the per diem.
It is not by extension, by implementation of law, by operation of law. She herself. I didn't say so. She said that when your spouse occupies a public office, especially an Article 71 office holder, the benefits, the allowances are not extendable to your better half, let alone your children. So when this matter came up, I was hoping that she would have led evidence to the effect that yes, as the CJ, my travels, whether official or private, are arranged by staffers of my office. But then my private travels are paid for from under my personal funds. That was not the kind of evidence that were led. She brought people to come and lead character evidence. The issues pertaining to you in the government of the petitions against you were not about your character. It was about the performance of your official functions. Those were so it's time. Let us do this at laws. First of all. And he knows that under NRCD 323, the Evidence Act 5758, is relevant. Look, the people are saying that you cause your office to pay for your official trip. Your evidence should be that, yes, my official trips were arranged by my office, but I did not authorize payment for that. Two, these are the kind of evidence you need. Two, if Hassan says the other gravamen of the issue, that the CJ abused her office by making direct recommendation to the president for persons to be appointed onto the Supreme Court from the Court of Appeal. If Hassan says that is a whimsical, frivolous, and of no consequence, a ground, I feel sad. Because that amounts to abuse of office. So can the CJ get up and say, for instance, that tomorrow I am appointing the commissioner for police or the electoral commissioner when your powers do not extend to that? So this is about mandate. So like Senior Kpebu said, she didn't have the mandate to make those recommendations. And the CJ presides the Judicial Council. It is the function of the Judicial Council qua Judicial Council, not the function of the CJ qua CJ. But you sidestep the constitutional creature of the Judicial Council and you make your personal recommendations. So those recommendations amounted to personal recommendations. So you were taking the mandate of the Judicial Council, personalizing it, and actually acting upon same. These are serious matters.
Serious enough
Because
serious enough to occasion the removal of the head of an arm of government.
No. Hold on. Serious enough to occasion an allegation. Serious enough to occasion an allegation. So somebody petitions. So it must be gone into. So she ought to have gone before the committee and said, oh, in doing that, I didn't act with a bad faith. I was acting with good faith. Because look, when you are charged before a court for the commission of a crime, there are two elements. The actus and the mens rea. As for the actus, it has happened. That is why you are being charged. But your duty before the courts is to establish that you didn't have the mens rea. So if these basic things eluded the CJ, I feel sad. Because she could have led evidence to say that, oh, in this matter, look, there were a lot of delays. And so I thought that, I even forwarded this list to the Attorney General like 2-3 months ago. And I saw that the Attorney General was not forwarding it same to the President for action. So I decided to do so. So if eventually it was established that I didn't have the mandate, I was actually not abusing my office. I was acting in good faith, that to bring this name to the attention of the President. This is how you lead evidence to recant. You see, the hearing will be looking at your intentions. That's what the act has happened. But when you go and call people to come and leave evidence,
that she intended to steal the money, or she intended
she
to
intended
embezzle,
for the people to benefit
Hassan,
from those
Hassan,
without just cause.
No, is he Rock?
Hassan, please listen to me. Hassan, listen to me. I am saying that my first point was that the CJ herself ruled that Article 71
you need to allow me to respond to
this. You responded.
No, but it's not your
Rob,
time.
you made this point already.
Let me just from him, I'll come to you. So just
let me just address this one.
He's made a point already. Wait, let him land, and you come in.
The issue Article 71.
You come in.
I am.
Yes. So Roxy,
I am
conclude.
saying
Yes.
that the CJ herself hung. So the CJ hung herself in respect of the travel that was sponsored by
Roxy, are we not getting into the arena of absurdity? So, for example, President travels with the spouse. Who pays for the spouse travels? Who pays for the plane tickets?
Speaker travels with the spouse.
Exactly. So,
ministers in our appointment
where
letters
will we be getting to
that we are
if we are to implement this
with our spouses
the way
and
you
children?
say?
Can I make my point?
Yeah. So answer the question.
Can I make my point?
Yeah, answer the question.
So this became a subject. Hold on. Has the president ever traveled and it became a subject of audit findings?
But is it also in Article 71?
Hold on.
Does the president have the mandate under Article 71 to travel with his spouse and his children? Just like you're positing.
No.
Yeah, so Roxy, let's respond to that quickly.
Hassan, when you were speaking, I was quiet.
Yes, Roxy.
So I am saying that once it became a subject of audit findings, the audit establishes that it breaches the law. When something breaches the law, you either deal with it or you are culpable.
So your point is that in the case of the president and the vice and all of that, it does not become a subject of an audit report. So we can't say there's anything wrong with that now. But because CJ's own has become a subject
the audit must hold
of
on,
an audit report, we can deal with it.
Can I
yes,
finish?
Go ahead. Yes, you have
Can I finish? The audit must establish that the president actually traveled with the wife on the public purse and paid for by the public. That is an audit. That's a subject of an audit. We are speaking to a matter that became a subject of an audit report. So don't let us make suppositions to muddy the waters. These
well.
were the gravamen of the petition before the committee.
Very well.
And please, third, the committee is not a court of law. It's a creature of the constitution. They have their own procedures.
Precisely.
Very well.
Precisely.
So great. So
Yes.
Roxanne, hang in there.
So the
Hassan,
first
yes,
point,
let's
the first
respond
point
to that
about
quickly.
the Article 71. Look, we all know in this country, the president travels, state visit with the spouse. Does it find expression in Article 71? It's not stated there. But you see, you have not even seen the instrument of appointment of the Chief Justice. I, as a deputy minister, my appointment letter states that you are entitled to a vacation with your spouse and your children who are below 18 years and so on and so forth. It is not stated in Article 71. As CEO of NPA, I was entitled to it. You understand? So these are stated in your
That you
instrument
travel with your wife
of appointment that you are
and
entitled to a
children,
vacation.
and your wife is entitled to per diem.
You understand? You are entitled to travel.
Yes, if you travel with your wife, the company pays your wife
Those
per
things,
diem.
the company will pay for those
Really?
things. And sometimes even silent. So it becomes a discretionary issue for you to decide whether to pay your spouse or not to pay your spouse. But you see, there is a history. Some people have been Chief Justices before. Justice Eni Yebua was Chief Justice. Justice Sophia Akufu before her was Chief Justice. All right? Now, all these people, I am reliably informed,
That they were at the
testified. And they benefited from this same provision. You understand? Justice Sophia Akufu, obviously, it didn't have a husband, but she was entitled to this thing.
But would that make it right? The fact that people did it
I'm
in
saying
the past,
that, I mean,
it wasn't seen or captured.
You see,
Roxanne, can you note down your points?
When you
I
go
come
to
you,
Article
respond,
7, Article 57, you find the order of precedence.
Yes.
There are 4 people who are listed there.
The president,
The
vice
president,
speaker,
the vice president,
and the chief
the
justice.
speaker, and the chief justice. There's a very good reason why they are listed there. They are special beings. You understand? If you pay for the spouse of the chief justice, the speaker of parliament, or the vice president or the president to travel on a vacation,
And the daughter.
what's wrong with it?
And the daughter.
You understand?
Those are above
These are
18.
people, exactly. These are people who are carrying the burden of the state. They are just 4. So why should the others benefit and then this one cannot benefit? You understand? And secondly, he's talking about a committee. Look at what the committee did in the statement that was issued by the secretary to the president. Point 3.4. The committee states without fear or favor that the Chief Justice unjustifiably breached the provisions in Article 296A and B of the Constitution 1992 in a way and manner that she transferred Mr. Baden. Her conduct amounted to misbehavior. Now, is the committee supposed to be interpreting Article 296? Who does this? You are saying that the committee is not a court, but the committee has arrogated to itself the powers of the Supreme Court under Article 2 of the 1992 Constitution
Is the committee
to make pronouncements.
not applying?
You understand?
The
they are
provision,
making
rather.
pronouncements that she was in violation of Article 296 A and B.
Yeah.
Now, is that a Supreme Court sitting?
Is this an
you
interpretation
understand?
of it, or is it an application
Precisely.
of the provision? No,
I mean, you can't talk about violation.
Is there an application of the
They
296
said that
provision?
if there is, what are the Constitution say under Article 2? A person who alleges that B, any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect. This committee is not the Supreme Court. Why would they be making such declaration?
Very well.
You understand? So really and truly, I think that the committee was set out to do a job, to arbitrarily do the job that they have been asked to do, oppress, and in a very unjust manner remove the Chief Justice of the Republic. And that is a very dangerous precedent. Look, take it from me. Any president who comes to office would walk in with his Chief Justice.
I see.
Take it from me.
Yes. On that note, Martin, we have a Constitution Review Committee which is currently at work. What should Professor H.K. Prempeh's committee be thinking in light of all these processes to remove the CJ? Indeed, the argument has been made that amongst the 3 primus inter pares, as he wanted to call them, the so-called special beings, the CJ is the one easiest to remove. In the case of the president, you need to test majority. There's an elaborate process you have to go through, etc. In the case of the speaker, I think you need 3/4 of members of parliament, which is very difficult to garner before you remove him. In the case of the CJ, we just need anybody to submit a petition to the president, and the president, as we have come to know, becomes just a conveyor belt, and the process kicks in till it concludes. What should the Professor H.K. Prempeh's committee be looking at in respect of ensuring judicial independence, security of tenure of office of Superior Court justices, and for that matter, the Chief Justice, so that they do not become so pliable to the executive?
Okay, so Salom, you had earlier on stated that when it comes to the removal of the Chief Justice, the president is not a conveyor belt. He sits in judgment in the prima facie case, and also he does the suspension. So that's different. He is only a conveyor belt if it becomes
after the committee
a matter of
submits its report.
Yes, and also if the removal is or concerns another justice of the Supreme Court who is not Chief Justice. Yes, but to give judicial independence, we had already started making a lot of noise, advocating since last year when her letter to Akufo-Addo came out, that in the new constitution, we don't want the president to be the one to appoint the Chief Justice under Article 144. We don't want it. So 144 out. We had been, you remember last year, as you rightly said, the moment we saw that Chief Justice Torkonoo had written to Akufo-Addo, etc. So we said no. Article 144, that's 5. He says, justices of the Superior Courts and chairman of regional tribunals shall be appointed by warrant under this, under the hand of the president and seal, blah, blah. Then you also know that specifically when it comes to the Supreme Court, is the president appointed by the president acting on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament. So we want to remove the president from the whole process. And also the removal process, one of the things we should do is that we should be able to categorize to know what are serious offenses and what are minor. I like to refer to the Police Service Regulations, CI 76, and a whole lot of other public sector organizations. You see that in their regulations, they're able to tell you which one is a minor offense and which is a major one. So, and yeah, we've written about it on Facebook. I even did that categorization. So these are the two ways we think that we should strengthen judicial independence.
So should Parliament have a say before the Chief Justice is appointed and sworn in? Parliament has a say. Parliament vets the CJ nominee and approves or otherwise. Should Parliament have a say in the removal of the CJ as well as the Parliament will have a say in the removal of the President or Speaker?
No, we'll be making Parliament too powerful. Let's not, we are not doing a parliamentary democracy. We are doing a hybrid. I don't think when it comes to the removal, Parliament should have a hand. They should have a hand in the approval. But in the removal, let's situate it within the Judicial Council and let's put very stringent measures, okay? Because if you concentrate too much power in Parliament, Parliament will become undemocratic. Yeah.
Very well.
Too much power. Constitutionalism requires that you share the powers among multiple organizations. Don't concentrate too much power in one person.
That takes care of this impeachment.
Yes. So great. Let me seek the view of Honorable Dafemekpo on this. Let me seek the view of Honorable Dafemekpo on this. I mean, same question, Honorable. The removal process. We've all said that it's so easy to remove the CJ. Now that we are contemplating amendment to a constitution or a new constitution, how should we tighten this so that tomorrow a president doesn't walk into office with his own CJ and leave with his own CJ? Hello, Roxanne. Kindly unmute, Roxanne.
Hello. Hello.
Yes. Do you hear my question? Yes. We are okay now. Do you hear my question?
Yes, I'm saying that I disagree that the removal process under Article 146 in the Constitution of a CJ, a Supreme Court judge, or any of the Superior Court judges is whimsical. It's easy. It's not. It's such a laborious process. So the problem is that where your sins are such that you cannot be saved, you cannot be saved. The process, we can even say that you yourself should preside the committee for your removal. Where your sins are so diabolical, you go.
Honorable, look, just look at this. Article 1466.
Yes.
The president appoints a committee of 5, 2 Supreme Court justices, and 3 other persons.
Exactly.
So the president can choose to appoint 3 people. They could be anybody. And in the end, there could be a majority of 3. And majority will carry the day.
No. You've forgotten that even the CJ itself was appointed by the president. Have you forgotten?
Yes.
Supreme Court judges are appointed by the president.
Exactly.
Hold on. Court of Appeal judges are appointed by the president. High Court judges are appointed by the president. It's only the members of the lower bench that are appointed by the Judicial Council with prior approval from the president.
Yes.
So I am saying that at any time, your conduct must be such that it must be above reproach, like Caesar's wife.
Yes,
but where the
Roxy,
evidence...
The point we're making is that if a new president, for example, doesn't like a particular CJ, it's easy to have people petition. Prima facie case is, established. A committee is set up, and the committee, 2 of the members by constitution should be Supreme Court justices. That's fine. They could be whatever. Let's even assume that they may not be in agreement with a particular regime's, intention to remove a CJ. But there are 3 other people whose qualifications have not been stated. There could be 3 people, three people. There could be any kind of persons, as long as they are not lawyers, judges, etc. They will sit there and the president chooses them. They will vote. They will vote, and once they vote, it can be 3-2, and then the CJ is gone.
Have you ever appeared before the disciplinary committee of the judicial? You have representatives. Hold on. Hello.
Yes, go ahead.
You have representatives of the bar on serving on the disciplinary committee of the General Legal Council. You have judges serving on the General Legal Council. You have representatives of other institutions serving on the General Legal Council. But when it comes to the disciplinary committee, it is specially constituted. Lawyers have been fighting that they don't want judges to be disciplining them.
Yes.
So
what's the point? Yes.
The point is that the CJ herself supervises an institution which is the General Legal Council, which is dominated by judges. That sitting judgment over conduct of lawyers. Lawyers are not judges. But every day they sit in judgment over conduct of lawyers and discipline them. Good.
And who
exactly. Why the people, hold on. The people who are sitting in the Article 146 committee are they not seized with matters of law?
No, they don't have to be lawyers.
Hold on, Hassan.
They are not supposed to be lawyers or judges.
Good. Hold on. The people who constituted the Constituent Assembly and formulated the Constitution, you think they are ignorant?
No, but Martin,
the person who,
for example, they said they were going to. They said they were going to apply.
So let me finish. This is my time.
Wait. Let me finish. This is my time. But I have the right to interrogate it. They said they were going to work with.
So I'm saying that
CI 47.
In the same way.
And how can lay people understand and apply CI 47?
Hello.
The CJ made a case.
Yeah.
When the prima facie case was
hello.
being made.
Yes.
Hello.
If you say that you are going to apply CI 47.
Hello.
Under CI 47.
Roxy. Yes.
Roxy, let me just make a point quickly, then you can respond.
Hassan, when you speak, we keep quiet.
Yes.
Roxy, this is not parliament where leaders take precedence over everybody.
Maybe I'm the speaker. No, I'm the speaker here. I'm the speaker here, and you can't remove me easily. So Roxy, you have the floor. Yes. Roxy, conclude your point.
So I'm saying that judges get the opportunity to sit in judgment over conduct of lawyers. When it comes to judging the conduct of judges, lawyers also get the opportunity to sit because you see they are members of the Judicial Council, and the Judicial Council has a disciplinary committee. It is constituted by the general membership of the committee, which use the membership to a disciplinary committee. So this CJ that has been removed, she removed a judge from the Jessica District Court on ground of conduct.
On what grounds?
Good, because
On what
somebody
grounds? Do you remember the
petitioned
grounds?
against the conduct of the judge.
Yes.
Can I finish?
Yes,
Stated
go ahead.
misconduct.
Make your point, yes.
Stated misconduct. That was all. Stated misconduct. The woman who filed the petition then gave the facts of the matter. She constituted the disciplinary committee of the judicial. Going to they brought a recommendation. When they brought a recommendation, she acted upon the recommendation. You, as a CJ, you can determine somebody's fate, given the procedure provided under law. But another procedure provided under law regarding how you should be removed when it is acted upon, it is wrongful.
All right,
I beg your pardon.
Great. I take a short break.
I beg your pardon.
Yes. Let me take a short break. So, Roxanne,
I beg your pardon. So,
just
if the CJ, but you see, I don't know. Let me make this. You remember that when Charlotte Osei was removed under Article 46 procedure, Kwaku Bakun went to the Supreme Court to challenge it, isn't it? TJ can go to the Supreme Court to challenge the findings and the recommendations of the committee. That one, she has that right. Nobody should think that this is it. This is the end. Kubaku went to the Supreme Court, but he didn't find favor with the court. It doesn't mean that the findings of this committee cannot be challenged in the Supreme Court. It can.
Very well. Let me take a break. So I take a short break. When I come back, we will explore what this means for the CJ, Gertrude Torkonoo. Can she still continue to be on the Supreme Court bench as a justice and not as a CJ? We'll try to answer that. What does it mean for her retirement benefits, her emoluments? Normally, the Supreme Court justices and a lot of the Superior Court justices retire on their salaries and other benefits. Will she retire? Will she go home with her salary, or she loses everything she's been fighting for as a judge in the past 21 years or so? This is the point of view on Channel 1 television. We'll be back with more. Don't go away.
Kwame and his uncle are almost here.
Wait a minute. This one too, your friend Kwame.
Wait, Kwame. As in the same Kwame again?
Yes, Mommy.
I'm
the second coming.
Into all this tension just to reintroduce that broke boy from Kaswa.
Why would you deceive the family like this again?
Now I understand the whole delay. Trotro from Kaswa. Why wouldn't he be late? Or be late? Of course.
Star 712 hash, star 712 hash. Yeah, you go give me the luckiest. Coffee from Georgia be luckiest. From not the cause she be luckiest. Yeah, you go give me luckiest. No bugger why that luckiest. Everybody go be that luckiest.
God Kwame!
Send your God the apple boom. If you put it toye, so would the coming of the Son of Man be. Is that his car?
Dial star 712 hash. Choose your ticket. Enter your lucky number. Follow the prompts and let destiny handle the rest.
This promotion is regulated by the NLA on the Caritas platform.
This is the point of view. You're welcome back. Your messages are coming. Keep them coming in. We'll read them before we close. Now, let's get to the final leg of the program. So, CJ Torkonoo is being removed from office by operation of law. What does it mean for her? Can she continue to be on the Supreme Court bench as a justice, because she was a Supreme Court judge before she became a Chief Justice? And if she's being removed as a Chief Justice, can she go back and sit as a Supreme Court judge? What does the law say? And what did the warrant that was revoked say about this particular point? Hassan?
As far as I'm concerned, I think that we have to look at the petitions that were submitted to the president. The petition by Shining Star is headlined...
But the Shining Star one is not...
Yes, I'm just reading all the petitions. The petition by Shining Star says, petition for the removal of the Chief Justice of the Republic of Ghana, her leadership, through Torkonoo. And this is the petition for Daniel Ofori. Petition for the removal of the Honorable Chief Justice, her leadership, blah, 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 blah. The one from my classmates, Mr. Yamga, also said petition for the removal of the Honorable Chief Justice. So there's no reference to her removal of a justice of the Supreme Court. So the reference, of course, is to her administrative functions. Because under Article 1273, her judicial functions, when she exercises them, are not impeachable. So I take it that the challenge is to her position as a Chief Justice. So ordinarily, the committee's reliefs should be limited to what had been pleaded.
But if they're removed as a CJ, I mean, the misbehavior will not allow you to continue to be a justice of the Supreme Court.
If you are a justice of the Supreme Court, you will not be engaged in approving per diems. You see what I'm saying? You will not be engaged in proposing names to the president for appointment as justices of the Supreme Court. You will not be engaged in transfer of people.
Won't it lead to an absurdity? For example, she is removed as a CJ, she remains on the Supreme Court bench.
Yes.
At some point, she becomes a senior most after the CJ. The CJ is traveled, or the CJ is unable to perform the function over a period of time. Now the senior most has to act, and the person who was once removed as CJ now acts. Wouldn't that be an absurdity?
Yeah, that absurdity definitely will arise. So we need to test the law to be sure what the scope and effect of such a removal is, especially when the Chief Justice is removed.
But what did the warrant say? The warrant, the final page.
The warrant says that she is removed as Chief Justice and also a Justice of the Supreme Court.
So let's go to the final page of the warrant.
That's what the warrant
the president's signature is. It says that now, therefore, know ye all men that I, John Dramani Mahama, President of the Republic of Ghana, in pursuance of the said Article 1469, do hereby remove the said Chief Justice, Justice Gertrude Araba Isaba Saki Torkonoo, from the office of Chief Justice and Justice of the Supreme Court, with effect from the date hereof, in witness whereof I have hereunto set my hand and caused the presidential seal to be affixed at Accra this 1st of September 2025, signed by the President John Dramani Mahama, President of the Republic of Ghana. So this essentially means that she's been removed as Justice of the Supreme Court as well.
Court, yes.
So she has to go home.
But what I'm saying is that the petitions
did not seek this relief. But are they not joined? I mean,
but they haven't said so in the petition. And we are not privy to what transpired.
Removing the CJ, doesn't that go without saying that once the person is removed as CJ, it goes with it, because you become a CJ after you've
become a justice of the
Supreme Court.
Yes.
So it goes with it. It's conjoined.
Not necessarily.
Let me see what
Martin. These are grey areas that we have to test.
Let me see what Martin thinks. Right? Martin, of course, we see the warrant. The warrant also removes her as justice of the Supreme Court. But is that the way to go? The reliefs being sought, or which were sought by the petitioner, from what Hassan is saying, did not seek her removal as a Supreme Court justice. It only sought her removal as a CJ, perhaps administrative duty. Is it right to remove her as a justice of the Supreme Court as well?
Absolutely, absolutely. The arguments that are being foisted on you are what we call a distinction without a difference. Distinction without a difference. Hello, when you go to Article 144, right, you see appointment of Chief Justice. Now, the argument that has been urged upon you, when you go to this, what do you call it? The 146. It says that the removal is removal of a superior court judge. When you look at the grounds, So if it's now being said 1461, it talks about a justice of the superior court. It doesn't make different provisions for a chief justice. So you don't have different grounds for a chief justice. So I hope you are getting my argument.
Yes.
When you go to 146, there are no separate grounds for a chief justice. It's for a superior court judge. So whether high court judge, whether electoral commissioner, whether National Commission for Civic Education, whether, you know, all of them, it is the same grounds: incompetence, infirmity, and then what do you call it? Stated
misbehavior.
Behavior. So what is happening is that obviously you could see that from everything you read, it was removal under 1461. So tell me, if you say they were not removing the Chief Justice as a Supreme Court judge, where? Which provision, which grounds were they using to remove it? The grounds are in 1461. And when you go to 1461, it doesn't even mention Chief Justice. My point is that 1461 doesn't even mention Chief Justice. And
those are Superior Court justices. So
yes,
the grounds for the removal of Superior Court justices is the same, even though the procedure may differ a bit when it comes to the Chief Justice. Is that the point?
Absolutely.
Great.
So there are no special grounds for removal of a Chief Justice. The Constitution has not made any special grounds. So it's actually your removal as a Supreme Court judge, and ipso facto, your removal as a Chief Justice. Simple. This one, there is no two ways about it.
Very well.
It's open and shut. This is what we call in law open and shut. There can be no sophistry about this. There are no separate grounds for the removal of a Chief Justice. Everything is just the 1461. And 1461 only knows Superior Court justices.
All right, Martin, quickly, talk to me about what others, or what some have called the timing of the removal. Today, there's a by-election highly contested tomorrow. Is it incidental, coincidental, or you think it was done on purpose?
Hey, Salam, this one here, I don't have a crystal ball. I have an ordinary cat. I know, to be honest, I have no basis to think that it was done on purpose. I have no basis, because what would be the purpose? We are going to a by-election tomorrow. I fail to see what the removal of a Chief Justice will have to do with the by-election. Rather, what I see is that, you see, it's a move to make sure that we get closure, because, you know, as long as these cases linger on, you know, we are suffering a lot of reputational damage as a nation, because we've been taken to ECOWAS Court, Ghana Supreme Court, High Court, and now the Bar Association of England and Wales, and then Commonwealth Lawyers Association. The Ghana has been reported to all these institutions, and so it doesn't look clean at all. It's a bit tacky. So I would think that it's a move to try and close this matter, and so that we can heal as a nation and then forge together, you know, for the reset.
There are others. There are some who think that because of tomorrow's election, I mean, if you do this today, by the time we get out of the election and the results and everything, this discussion would have died down and would have been talking about the election. So it's a good time to do it, so that tomorrow the events will be overtaken by the aftermath of the election.
Well, okay.
Let me let not the politician. Let me let the politician.
I'm surprised that Martin is running away from this political one. Because he's the one who has been injecting politics into all of this discussion. But see, the truth of the matter is that there is a certain indecent haste in dealing with this matter. Why am I saying this? There are 3 petitions. The first one has been heard. We haven't heard the second or the third, regardless of the fact that the committee has found, you know, merit in the first petition. There should have been time enough for us to go through the second and third petition. What the chairman of the committee said when he met the president was that the Chief Justice and then the other petitioners have sought an adjournment so that in due course they will come and then hear those ones. So he says that they will now go back and hear those petitions. Hear those petitions for the removal of who? Because you have concluded on the first petition. You have removed the woman as the Chief Justice already. So what are you doing with the second and third petitions? So yes, I agree with some people who can see some nexus between the haste in this decision and the election that we are going to have tomorrow. But take it from me. Tomorrow by 6 o'clock, MPP is retaining Akwatia. And this is not a seat that is like one of those seats that NDC can easily win. Anytime that we win with a huge margin. When there are problems in our party, that's when they slip in and they win by some 600 or some 400. We win by 2,000. We win by 5,000 and so on and so forth. So it's not a seat that, NDC can lay claim to and pretend that, oh, this is our seat. No, this is not their seat. We'll win and we'll come back and we'll discuss this removal of, unjustly removal of the Chief Justice. You see, this Chief Justice, even if she was found outside eating kinky, they would have removed her.
But will you say that she brought this upon herself?
How?
Because people have questioned how she handled the Afenyo-Markin case on the vacation of seats in Parliament and a few other things, to suggest that she was leaning towards a certain direction.
But you see,
the speed with which that particular matter, for example,
the procedure for removal of Chief Justice does not even include the political coloration, the judicial philosophy, or whatever of the judge. Assuming she was even associated with the NDC, Justice Scott Parman, he was the secretary, general secretary of the PNC.
But PNC is not contentious.
No, I'm just
PNC
saying
is
that,
not contentious.
But he was.
And besides that, he resigned.
You understand? But he was one time.
But PNC is not an issue.
No, I'm saying that he was political. Regardless of that fact, he was still put on the Supreme Court.
Yeah, but the contention in Ghana is about NDC or
parliamentary candidate of the MPP. He has also
so that is contentious.
So your political coloration does not even determine whether you should be removed in such a manner.
Let me take
in a manner that will even make her lose her entitlement under Article 155, because Article 155 talk about retiring. It doesn't talk about even removal from office of a judge. So what it means is that a judge who had worked as a Superior Court judge for 10 years straight would have been entitled to, those retirement benefits equal to the amounts that is paid to an incumbent judge, all right? Or anybody who has worked in the public service cumulatively for 20 years, 5 years of which was on the Supreme Court or Superior Court, the person is entitled to those retiring benefits. But it is silence on somebody who has been removed. You understand? So it makes easy for one to conclude that she's going to lose.
She'll lose everything.
I mean, that is so
unfair. Can we seek an interpretation on this to see whether
there ought to be an interpretation? But I think that you can't just lose all your entitlements like that. I don't think that provision should apply.
Will you take it up in court?
Oh, of course. I mean, I'm sure there are interested parties who will be willing to take it up.
Let me take a few messages. Novijro Bernard Tactic from Keta in Tegbi says, instead of us asking the content of the petition to see whether they will be a ground for removal, the MPP is only talking about bad precedents. Should we hide behind bad precedents and allow people like CJ act as if they are above the law? Mahama must be more courageous and ruthless in dealing with people who take the law into their own hands. Oral is delaying, Mr. President. This one from Jones Adoboy in Las says, good evening, Salom. The law is no respecter of persons. And insofar as the processes and procedures have not been breached, the law is the law. Have the procedures been breached? Because this is a question that a lot of your guys have been running away from.
Yes.
Have the procedures been breached? 146, any procedure there been breached?
Yes.
Which one?
We have said that the committee's hearing, the procedure that was adopted at the committee and what transpired at the committee ought to have been allowed to challenge. But the Supreme Court mounted a shield and said that, look, what is happening there is protected under Article 146.
But that's the Supreme Court.
I'm saying that, yes, but what we are saying is that even when she went to the human rights courts to seek vindication of her rights, under the
court dismissed it.
So
that's the court.
So at what point? At what point would the person have the right to seek a protection? You understand? So when the process starts, you are just there, you are dead. So taking your spouse even into the room was a problem because
they said that in-camera nature of
exactly.
the
In-camera means that it shouldn't be held public.
Yes,
it is
so
not a
bringing the public in there means you are defeating that
no,
because your spouse could mean the
in-camera
public.
is not supposed to be public.
Secret, yes.
Oh, you understand?
Very
so
well.
bringing your spouse in does not amount to violating the in-camera clause in the Constitution.
Thank you so much, Honorable Hassan Tampuli, MP Gushewu, and ranking member on the Constitutional Legal and Parliamentary Affairs Committee. Martin
now
Pebu.
it's Constitutional and Legal.
Just Constitutional Legal. Okay, Constitutional Legal Committee of Parliament. Martin Pebu, private legal practitioner, very hard man. Thanks so much for being on the program. Of course, earlier you heard from Roxin Dafamako, Majority Leader and Majority Chief Whip and MP for Southern. My name is Selom Adonu. Oh, I didn't know you were there. You were not there. So, no, I was calling you, but you're not there. I mean, but we'll talk more. Okay, Roxy, you have 30 seconds.
We've closed.
30 seconds.
Great one. The CJ's remover goes to a remover as a Supreme Court judge. Everybody should go and read Article 146 very well. You cannot, for instance, if you are removed as IGP on grounds of misstated conduct, can you go back to serve as a commissioner of police? The judge that the CJ removed from the Jessica District Court, did the judicial service pay him his entitlements? So this, when you are removed, you are removed. It's a punishment for misconduct.
Very well. Thanks so much, Roxy.
It's a punishment for misconduct.
Thank you so much for
that.
that.
Entitlement payments do not come in.
Thank you. Thank you so much. So that's how we conclude today's edition of the program. I sat in for Bernard Avle. My name is Selom Adonu. Have a good evening.